Welcome to You Be the Judge. Episode 1. Should Dad get more time with his daughter? Have you ever disagreed with a family court decision? Have you ever read a story online and thought, that's ridiculous, I know exactly what I would have done? Well, today you get the chance. Each week, I'll present a family law scenario inspired by the kinds of disputes that regularly arise in family proceedings. And your job is simple. You listen to the facts, consider the evidence, and decide what order you would make if you were the judge. Then we'll compare your decision with the outcome reached in a very similar situation. But before we begin, a quick disclaimer. The scenario you're about to watch is fictional, but inspired by many real family law cases. It's not based on any one individual or family. Instead, it combines elements from a range of real-life situations and professional observations. Any names, places, dates, and identifying details are entirely fictional, and any resemblance to real people or cases is purely coincidental. The court's decision in this episode reflects the types of reasoning and outcomes that can arise in family law proceedings, but it's not a recreation of any specific judgment. This series discusses the law of England and Wales only. Family law differs between jurisdictions, so the information in these videos may not apply elsewhere. Nothing in this video constitutes legal advice. Every family law case depends on its own unique facts. I'm Neil Andrews, a Mackenzie friend, providing legal support services through First Family Law, and the views expressed in these videos are my own. If you enjoy this series and want to see more real-world family law scenarios, please like the video, subscribe to the channel, and leave your judgment in the comments. And of course, if you need practical support with your own family law matter in England and Wales, you'll find details of First Family Law in the description below. Now, let's begin. Here's the situation. Meet Sophie. Sophie is 9 years old. Her parents separated about 4 years ago. Since the separation, Sophie has lived primarily with her mother. Her father spends time with her every other weekend from Friday after school until Sunday evening, together with one evening visit each week. For the past 2 years, those arrangements have worked reasonably well. There have been no other court proceedings or anything like that, no major disagreements, no police involvement, no social services, nothing particularly dramatic at all. But now things have changed. Sophie's father wants more time. Quite a bit more, in fact. When many people hear about family court disputes, they immediately assume that there must be allegations, perhaps domestic abuse, perhaps substance abuse, perhaps concerns about parenting, but not this time. There are no safeguarding concerns, no allegations of abuse, no allegations of neglect, no concerns about drugs or alcohol. In fact, nobody's saying that either parent is unfit. In fact, everyone agrees on one thing, that Sophie has two loving and capable parents. The disagreement is simply about what arrangements would be best for her. And often those decisions are the most difficult cases of all. The father says he has become much more involved in Sophie's life as she has grown older. He attends school events, he helps with homework, he takes her to activities, he has suitable accommodation, he has a stable job, he has flexibility in his working hours. He says he can meet all of Sophie's day-to-day needs. His argument is simple. If both parents are capable, why shouldn't Sophie spend equal time with both of them? So he applies to court, asking for a week-on, week-off arrangement. 1 week with mum, 1 week with dad. 50-50, as many people call it. From his perspective, this is about being a fully involved parent. He doesn't just want to be the weekend parent, the weekend dad, the Disneyland dad. He wants to do the school run, parents' evenings, homework, medical appointments, bedtimes, the ordinary things that make up a child's life. So he tells the court, I don't want to simply visit my daughter. I want to parent my daughter. Now, in contrast, let's look at the mother's position. The mother opposes the application, not because she wants to reduce contact, not because she has concerns about the father's parenting. In fact, she says she actively supports Sophie's relationship with him. Her argument is different. She says the current arrangements work. Sophie's school is 5 minutes from her home. Her friendship group is based nearby. Her dance classes are nearby. Her routines are established. She says moving between two homes each week would create disruption where none currently exists. So she tells the court, Sophie is happy, she's settled, there's no need for a major change. And that's the dispute. Two reasonable parents, two understandable positions, one child, one difficult decision. What does Sophie think? The court receives information from an independent professional who spends time speaking with Sophie. Now, this is something that often surprises people. Children do not simply make that decision. They do not simply decide where they live. Family court isn't a referendum. A child doesn't cast a vote, and that's the end of the matter. However, their wishes and feelings can be an important part of the overall picture. When Sophie is asked about arrangements, she said something interesting. She says she enjoys spending time with both parents. She said she would like to spend a little more time with Dad, but she also says she doesn't really like the idea of moving all of her things between two homes every week. That's all she says. Nothing dramatic. No rejection of either parent. Just a fairly typical 9-year-old's view. Now, you be the judge. It's your turn. Imagine you are sitting in court. You've heard the evidence. You've listened to both parents. You have considered Sophie's wishes. What order would you make? Option 1. Would you leave arrangements exactly as they are? Option 2. Increase the father's time but stop short of equal shared care. Or option 3. Order a week on, week off arrangement. Take a moment. Think about it. And if you're watching on YouTube, pause the video and put your answer in the comments. What would you do? Now that you've done that, let's have a look at how the court would approach this. Before we reveal what happened in a similar situation, let's talk about how a judge might approach a case like this. One of the biggest misconceptions about family court is that judges are trying to be fair to both parents. That's not really the question. The law says that the child's welfare is the court's paramount consideration. In other words, the child's welfare comes first, not fairness between adults, not keeping score, not making sure everyone gets exactly the same amount. The child's welfare comes first. The court may consider things such as the child's wishes and feelings, their emotional needs, their educational needs, the likely effect of any change in circumstances, the capability of each parent, and any harm the child has suffered or may suffer. Notice something important. None of those questions are what does mum want or what does dad want. Family court is ultimately child-focused. The arguments. If I was presenting the father's case, I'd focus on a few key points. First, there are no welfare concerns. Nobody's disputing his parenting ability. Secondly, children often benefit from meaningful relationships with both parents. Thirdly, Sophie herself says she'd like more time with Dad. And finally, society has changed considerably. Many fathers today play an active and equal role in raising their children. The father would ask, why shouldn't arrangements reflect that reality? On the other hand, the mother has some strong arguments too. Children often thrive on routine. Consistency matters. Stability matters. School matters. Friendships matter. The question isn't whether Dad is a good parent. The question is whether moving between two homes every week would actually improve Sophie's life, or whether it would simply create additional complexity. The mother would argue that if something is working well, there should be a good reason to change it. And that's why cases like this can be very difficult, because both parents can be entirely reasonable and still disagree. The resolution. So what happened? In the real-world scenario that inspired that discussion, the court did not order week-on, week-off care. However, it also decided that the father should spend more time with his daughter. The judge concluded that Sophie would benefit from an increase in time with Dad. The evidence showed he was committed, capable, reliable, and actively involved. But the judge was not persuaded that equal shared care was the best arrangement at that stage, particularly given Sophie's age, schooling, and established routines. Instead, the court increased contact significantly while maintaining a primary home base. In other words, the judge chose the middle option, more time with dad, not 50-50. Why? Now here's the really interesting part. Many people watching this will probably disagree with the outcome. Some will think the father should have received equal care. Others will think arrangements should have stayed exactly the same as they were, and that's perfectly reasonable. But the judge's reasoning focused on something important. The court wasn't trying to reward mum. The court wasn't trying to punish dad. The court wasn't trying to divide a child equally between two adults. The court was asking what arrangement best serves this particular child, and that's a very different question. And it often produces outcomes that don't really neatly fit into either parent's preferred position. One thing I've learned from family proceedings over the years is that courts are rarely looking for perfect solutions. More often, they're looking for the least imperfect solution. A solution that preserves relationships, supports stability, and promotes the child's welfare. Sometimes that means one parent gets exactly what they wanted, but more often it means that neither parent gets everything that they asked for. So did the court get it right? Would you have considered 50-50 care? Would you have left the arrangement exactly as they were? Or would you have increased the father's time without going all the way to equal shared care? Let me know in the comments. I'd be genuinely interested to see what conclusion you reached. Now, before you go, let's look at next week's case. A mother has been offered a fantastic career opportunity almost 200 miles away. She wants to move there with the child. She says it will provide better housing, better opportunities, and a fresh start. The father says the move would fundamentally change his relationship with the child. If she leaves, regular contact becomes almost impossible. One parent gets what they want, the other loses something incredibly important. So here's next week's question. Should a parent be allowed to relocate with a child, or should the court refuse permission in order to protect the other parent's relationship? If you were the judge, what would you do? I'll see you next week. Until then, you be the judge.